the Honorable Chief Justice, the Honorable Attorney General, fellow panelists, conference delegates. It is certainly great to be given an opportunity to network beyond the parameters of a police station, which is for most parts have been positive and negative. But then that's the normal relationship between police and lawyers, which you are all aware of. Speaking at the Aegis conference is likened to jumping into a shark tank, considering the vast knowledge and experience of the delegates and speakers seated in this room. And the Fiji Police Force welcomes this chance to speak about a topic that is quickly becoming one of our emerging and worrying crimes. The reality is that a few years' time, the policing landscape will shift dramatically from routine policing out on the front line to more policing of cyberspace. So to answer the question posed to us on whether we should regulate cyberspace, the answer is a definite yes. Is it difficult to measure the degree of if a person is culpable of a cyber-related offense, whether it be civil or criminal in nature? From the policing perspective, we are of the view that it is not difficult at all. Cybercrimes are committed by so-called professional criminals who know the intricacies of the World Wide Web. To commit a cybercrime-related offense, one will need to be equipped with the knowledge of how the internet works, so they are acting knowing very well that they will gain from their illegal activities. It is a point of argument that the act could be committed without malicious intent. If we are making reference to a child, there may be room for maneuver. But as we have seen lately, cyberbullying is real, and majority of the reports received involve children who are both victim and suspect. However, when it comes to serious and complex crimes that take a lot of thought and meticulous planning, culpability is an issue that can easily be determined. From the policing perspective, with the absence of a cybercrime legislation, which we hope is being drafted, we are having to source from and apply laws from other relevant and relatable legislations. As of now, the police's cybercrime unit is dealing largely with cybercrimes under the Crimes Act of 2009, where there are 10 sections under Division 6, computer offenses. These provisions allow us to investigate complaints where computers and its peripherals are either used as a tool to commit an offense or becomes a victim of a crime. Ladies and gentlemen, the provision makes specific mention of computers only and is silent on other digital devices such as mobile phones that have the capacity to store data and connect to the World Wide Web. However, with limited provisions, 156 reported cases have been investigated or are under investigation by the Cybercrime Investigations Unit since 2008. To bring things into perspective, 20 cases are still pending in court. 12 cases have been dealt with successfully in court, resulting in imprisonment sentences or fine on accused persons. This includes cases of trafficking in obscene publication, where we were able to lay charges under Section 377 of the Crimes Act 2009, obtaining property by deception under Section 317, obtaining financial advantage by deception under Section 318, abusive text message, Section 30 Alpha of the Telecommunications Act, Cap 173, money laundering under Section 62 Alpha and 3 Alpha Bravo of the Proceeds of Crime Act, number 27 of 1997, and Section 29 Alpha of the Proceeds of Crime Amendment Act, number 7 of 2005. Possession of property suspected of being proceeds of crime, contrary to Section 71 and 2 of the Proceeds of Crime Act 1997. These are some of the provisions that we rely on when cyber-related crimes are reported to us. With the remainder of the 156 cases I made mention of earlier, one of the major drawbacks is we could not progress further due to the absence of specific laws. Not only are we facing challenges with the application of specific laws relevant to the criminal element of a case, we are also faced with drawbacks of not having the lawful authority to investigate or proceed with certain investigative elements of cybercrime. For example, if a suspect refuses to provide the password to his or her computer or mobile phone, we cannot lay charges against him or her for refusing to do so. Ladies and gentlemen, the Crimes Act, however, does not begin to capture the complexities and the diverse range of cybersecurity breaches that occur in Fiji, which affect the cyber environment and infrastructure. One of the challenges of the cybercrime unit and law enforcement authorities is that when complaints are investigated, criminal charges cannot be brought against alleged offenders for the simple reason that there was no express legislative provision criminalizing the behavior. Ladies and gentlemen, Section 336 of the Crimes Act does not cover the diverse range of cybersecurity breaches. Many of the cybersecurity threats that are prevalent in Fiji around the world are also not properly described under Sections 340 to 346. Our investigations does not only focus on local citizens, but on foreign nationals who have come as far as Nigeria and Ghana and entered our country with legitimate travel documents, but with ulterior motives to use stolen MasterCards and credit card details to meet their traveling expenses. These individuals have been dealt with by our judicial system and have been sent back to their countries of origin. Since a cabinet decision was reached on the 30th of August 2011, work has begun in earnest, which I must thank the relevant stakeholders for facilitating consultations and meetings held to date that has led to the inception of the Fiji Center for Emergency Response Team. The Fiji Police, in line with the Ministry of Defense, National Security and Immigration via the Cybersecurity Working Group that was commissioned on the 5th of July 2011, has held public consultations between 2012 and 2013 and taken on board a wide range of recommendations. One of the major outcomes of the consultations with more than 70 secondary schools led to the inclusion of child online protection with regards to cyberbullying, online gambling, pornography, child trafficking, and soliciting minors for sex online or child grooming. The working group had started work on a draft on cybersecurity in consultation with the SG's office, and we eagerly await the outcome of that as we continue to liaise with various stakeholders through the ministry to identify areas of collaboration with various stakeholders to mitigate cybercrime offenses. With the continuous development of the ICT sector, which includes the increase in internet speed and connectivity, the finalization of our cybercrime law is vital to deal with the current and emerging trends of online offending. Through partnerships with institutions such as the Financial Intelligence Unit, we are working towards strengthening public and private partnerships to build digital awareness and digital literacy. We are heading in a direction where policing of crime will be more inclined to cyberspace and cybercrime as a national security issue. The days of pursuing a criminal suspect out in the field will gradually diminish as we focus on policing space where crime can be committed by the very person sitting next to you. We hope that today's deliberations will assist in mapping the way forward in regards to a cybercrime legislation. As I had mentioned earlier, the views of our children were taken on board during the consultation phases, because they are fully aware of the ramifications the World Wide Web has on their lives and their future. Ladies and gentlemen, thank you for listening, and I look forward to some constructive deliberations on the topic at hand.